Morning. Welcome to the Kentucky Realtors Buyer Agency Representation. As you all know, we need to use a buyer agency agreement whenever we're working with our clients and customers. So this buyer agency agreement has been brought to us by the Kentucky Association of Realtors. This form is one of many forms. You're going to use this form, go through this form. We're going to go through this form one line at a time. So again, you must use a form for your buyers saying how that you're working for them. This is just one form. This is brought to us by the Kentucky Association of Realtors. If your broker has another form that they would like for you to use, then please use the form that your broker has decided that your office needs to use. This is the Kentucky Realtors Buyer Agency Representation Agreement. We're going to start at the very top of the form. We do not fill or write contracts, we fill in the forms. So on this form, we have at the very top, key terms, buyer's name. You have two blanks to be able to print the buyer's name. Then you have the buyer's agent's name, the buyer's brokerage name. So buyer's name, whoever's buying the property, whoever you're working for, your clients, you're going to put their names in lines number 2 and line number 4. On line number 6, this is where your name as the agent is going to go in that line. Line number 8, you have the brokerage name. This is where your company is going to go. You also need to have your KRE, your license number. So up in line 6, it says KREC license number. Make sure you have the license number. You have a phone number and email on each section so that you can have contact information for everybody. We're going to scoot down to what is called the scope. The buyer hereby engages the broker as the buyer's exclusive agent to identify and locate the properties during the term and to help the buyer negotiate a contract for the acquisition of property. This agreement for the property in the following scope, the scope, complete all that are applicable. It says, if any left blank, then the scope shall be property in Kentucky. I am one of those that do not leave a blank. So fill in the blanks. Location, area, counties. You write the location, you write the area that you are planning on showing the properties. If this is a one-time showing, you're going to use this as a one-time showing agreement, then you're going to put a specific property address in that line. If you want this to be a buyer representation so that you're going to show them everything that you can find for them, then you are going to put the area or the counties. If you exclusively work in Warren County, then put Warren County. If you work in several counties, put Allen, Warren, Simpson, Barron, Butler, whatever the counties you happen to be able to work in. Personally, I'm not going to drive way out of my way several hours to represent somebody in another county. I will do a referral. This is your business. How do you want to do your business? You want to drive over there and you're going to work in that area? Just know your area. B, line number 15, approximate price range. You have already talked to their lender. You know what the lender says that they are pre-qualified for. This is what you're going to stick in there so that you know what the price range that they're going to look at a property in. Just be careful about this price range. If you happen to write down that the price is going to be, you're going to look for houses at $249,000 and less. If you sell them a property at $250,000 and you don't get it in writing, we'll discuss that later. That's outside of the scope. So, approximate price range, stick your numbers in that line. Types, what type of property? This form is recorded on single family residences, duplexes, fourplexes, anything that happens to be a residential. So what type of property are you looking for? Some areas work with condos and they're only interested in condos, then you're going to put that in. Specific properties, you're going to write down specific property addresses if you have specific properties that you are interested in showing. If you want to have all properties, I would put to be determined, but this is if you have a specific property that you're going to show. Again, the one-time showing listing would use the specific property because you know these are the houses you're showing them. I personally would hope to keep working with them until they buy something. Line number 20, buyer acknowledges that the additional specific properties may be added to the scope if the broker identifies in writing but not limited to email, text message, hyperlink, client portal, or under electronic message or format a specific property to a buyer during the term. So the buyer sends you a text message, says that they're interested in another property, or you send them a text message, just make sure you save your text messages. Emails, save your emails. Line number 23, the following properties are excluded from the scope. I would like to have none as my option, but there are times and occasions when you need to exclude a property. If they happen to be negotiating with their brother or their sister, and they might buy that property or somebody else out in the world, and they've already been talking to them and they do not want to have an agent involved in the transaction, then you would put that address that you will not receive a commission if they purchase that property. The other option would be, they already have somebody that they're working with and they want to remain loyal to that previous agent. That would be wonderful, sorry in this case, but if there is a reason they're going to be excluded from the scope, then this is where you're going to have your exclusion. Line number 25, an engaging broker, the broker buyer represents the buyer not currently contracted and will not through the end of the term or protection period contract with another broker agent to the same or similar scope. These lines right here, 25 and 26, are saying that they have hired you to be their agent and they are not going to get into a contract with another agent while they already have an agreement with you. Line number 27 has our term. The term of this agreement is from blank. You're going to put in a specific month and a date, comma, 2020, right now it's 24. If it happens to move over to next year, it'll be 25. Until 11:59 p.m. on a specific date again. So the month, the date, and then finish out the year. This is called the term. However, if the buyer enters into a contract for any property during the term, the party's obligations hereunder continue through the closing of the contract. Further, if the buyer enters into a contract for the property that falls within the scope, but within blank days, the attorney that created this form has put in there to say if blank, then 180 days, do not leave it blank. Put something in the blank, even if you do put his recommended 180 days. You need to follow your broker policy. Whatever your broker says that they want in that line is what you're going to stick in that line. After the expiration or termination of this term, the term is the protection period, the buyer shall remain obligated to pay the broker the fees through the closing of that contract. This is a protection clause. This says that you've done your job, you've done your work, and you've helped them on this property, that your commission is going to be protected if they come back and actually purchase this property. The next section happens to be broker fees. First statement on that line is there is no standard commission. I need you to make sure that you understand that there is no standard commission. It's going to be said many times. A buyer acknowledges that real estate brokerage commissions and fees, compensation are not standard, not set by law, and are fully negotiable during the term and any protection period. The buyer agrees to pay the broker the following fees. In bold, it says select all that are applicable. You are going to state how they are going to pay you as far as a amount. You have several different options. Let me go ahead and scroll this down just a little bit to bring this to the middle of the screen. You happen to have a percentage fee. So if you've agreed to a percentage, you're going to write the percentage in this line, whatever it is that you and the consumer have negotiated, what your broker has for their office policy and the broker has negotiated. This is the commission that's going to go in this line here. So blank percentage of either the gross purchase price of the acquired property set in the contract to be paid at closing, or if the transaction leaving a lease, the gross rental payments due made during the term of such leasehold to be paid at the earlier of execution of the rental agreement, or if the buyer taking possession of the property. We like to be paid this commission at closing, works out great. This is where everybody has come through. So if you happen to be getting a percentage, then you check the top box. Line number 40 down here, it says a flat rate. If you have decided that you are going to list the property and the listing commission is going to be a specific number, a flat rate, then you are going to write this specific number that the commission is being paid in this blank line. You're going to write it out as dollars and cents with words and then numbers and the last section. Again, you're going to check all that apply, so you could check section line number 36 and 40. This is all negotiable items. Getting down to line number 41, here is, it says other fees. This is a blank for you to stick another number in, and it says blank dollars and however many cents written out as numbers, and then written out in words, and then after that, it's written out in numbers. Again, written out in words, you see the word written out as dollars and specific cents. Then you see the dollar sign, those are gonna be specific numbers. Line number 42 is a large blank. In this blank, you're supposed to describe what these other fees may happen to be. These are paid by the buyer. This could be something as simple as a transaction fee, a closing fee, a document fee. Whatever the broker says for your office policy, that this is what you're going to stick in this line, this is where you're gonna stick here. So the office may have a base fee that they require on all transactions. You would stick that number in the base fee. So you could have section number 36 checked, section number 41 checked, or you could have all three checked. You could have section number 40 checked. You could have one of them checked. One of the items about this base commission, not the base commission, please forget that. One of these items about these compensation between sections 36 and 43, whatever you put on this form as far as numbers, percentage, flat rates, these are a contract. Which means if you put one number on here, you cannot receive more than that amount as far as your compensation, because your contract says this is how much you will be paid. There are situations where you can make some changes after the fact of the contract. If a seller happens to be offering a selling bonus to a buyer's brokerage office, then you would have to have an additional conditions form filled out for the client agreeing that you can be compensated at an extra amount. Again, you cannot receive more than what is listed in your commission or compensation. Your rate of pay cannot, office rate of pay cannot exceed whatever is negotiated here on lines number 36 to 43, unless you make some changes and get additional forms signed and filled out. Contact your broker to find out how they want you to handle something like that. But this is where you're being hired, this is how much they're paying you. Make sure that you get to the buyer's initials, dates and times at the very bottom of the page. You'll have to notice that right there on the bottom of that page. Let's go ahead and scroll on to the next page, page number 2. A, method and amount of the broker fees. During the term and any protection period, the buyer agrees to pay a broker fee in the amount and at this time set forth above if 1, the buyer or any party of the buyer process closes on the property pursuant to this contract, or fails to close on the acquisition of property and said contract the buyer is in breach of. And 3, during the protection period, the buyer enters into a contract for parties subject to the scope and subsequently closes on the acquisition of said property. Or number 4, buyer breaches this agreement. This is a listing agreement with your buyer. You are to be compensated. This is terms of how you're gonna be compensated. Item number B. This happens to be a section that you'll want to have a conversation with your buyers, because there is a possibility that you can get the seller to pay part of the compensation. Line number 51 says cooperating commission. A seller and or listing broker may but is not required to offer compensation to a buyer's broker or as a buyer's concession, such as without limitation as buyer's closing costs and paid as part of any offer made by the buyer. The buyer may request that the seller on behalf of the buyer's behalf, pay the broker fee under this agreement at the time of closing, either being a cooperating commission. In either event, these shall not in any way make the broker of this agreement a sub-agent of the seller. However, dual agency may still apply by separate disclosure and agreement. Further, in the event of a cooperating commission is offered by the seller or the seller's broker, broker will not, to the extent possible, before making an offer on behalf of the buyer, notify the buyer of the nature and amount of the cooperating commission. Long story short, seller can pay the buyer's broker commission. Line number 59, section C. In the event the buyer makes an offer involving a cooperating commission, the offer shall not be deemed by the buyer to authorize the broker to accept, and the broker shall accept such cooperating commission at closing. Number 61. D. Broker fees paid by a cooperating commission. At closing, the broker fees to be paid by the buyer shall be reduced by the amount of the cooperating commission as follows. If the cooperating commission or if the seller is not willing to pay the buyer's agent's closing fees, or if it is not as much, if the cooperating commission is a lower amount than what you have been hired for, then, number one, in the event the cooperating commission is equal to the broker's fees, and the payments of the cooperating commission shall satisfy in full the buyer's obligation to pay the broker's fees. In the event, number two, sorry, line 65, in the event the cooperating commission is greater than the broker's fees, the maximum cooperating commission shall be equal to the broker fees. I just mentioned that. I am so sorry, I should have waited for this line. Line number 67, 3. In the event cooperating commission is less than the broker fees, the buyer shall pay such difference in immediately available funds at closing. In other words, if there's a difference, then they pay the difference at closing. Line number 69, E. This section 6 survives expiration or termination of the agreement and protection period until closing on any property within the scope. However, after its expiration or termination of this agreement, the buyer is not obligated, not otherwise in breach of, buyer enters into another exclusive buyer representation agreement with another broker, then the buyer shall not be required to pay the broker fees herein. Scoot this page down. Section number 2, starting at line 73, says definitions. Several different definitions that they felt needed to be addressed in a purchase agreement. A, agent. B, agreement. C, broker. D, broker, buyer, broker, commission or broker fees. E, buyer. F, closing or close or closing. G, contract. H, property. You're a real estate licensed professional. I do not need to read you those vocabulary words. I'm trying to scroll the screen down here. All right. Section number 3, broker and agent duties. Subject to disclosure set forth below, the seller shall, A, these are saying things that you're planning on doing. Comply with his duties under Kentucky law, including KRS 324 and 201 KR Chapter 11. Those are where our real estate laws happen to be located. B, line number 89. Assist the buyer in identifying and locating one or more properties to acquire and to negotiate for the buyer to acquire the title to the possession of applicable a property, including without limitation, preparing a contract and related forms as permitted by Kentucky law. C, to hold any escrow, good faith, or deposit monies in accordance with Kentucky law, including KRS 324 and 201, chapter KAR, chapter 11, and any contract between the buyer and seller, that in the event of the conflict between Kentucky law and a contract, the broker shall comply with Kentucky law, and D, perform any other obligations set forth within this agreement. Buyer duties, the buyer shall cooperate with the acquisition of property, and B, pay broker fees. This is the bottom of the form. Since this is the end of page 2, make sure you get initials, dates, and times on the bottom of the form. And we will scroll down to page 3. C, still continuing buyer duties, conduct all communications regarding any property or contract with the seller and or the seller's broker through the broker. They're not going to talk to the agent or talk to the seller themselves. D, timely comply with reasonable requests by the broker to provide information or responses necessary to comply with terms of the contract and to close on the property. E, cooperate with the broker in scheduling visits, inspections, meetings, or similar events of a property at a reasonable times, and to attend all such scheduled obligations. F, line number 104. Reasonably, timely, and in good faith, investigate and conduct due diligence regarding any matter or interest of concern regarding any property in which the buyer becomes interested before the deadline set before them in the contract. G, seek independent advice with respect to zoning, construction, common property regimens, inspections, insurance, surveys, title appraisal, finance, taxes, mold or hazardous substances, termites, insects, law, or any other matter that may concern the buyer. We are not the expert in all things. We are the expert in real estate. They get to find their own information. You can direct them in the right ways to go. H, fully read this agreement and any other documentation the buyer is requested to sign, including a draft contract of any affiliated documents, and to consult with an attorney should a buyer have any questions about such agreements or documents. I, to work exclusively with broker regarding showings, offers, negotiation, contracts, closings, and to inform other brokers, sales associates, or third parties listing or selling property that fall within such exclusivity that the broker exclusively represents the buyer. The buyer needs to tell everybody they come in contact, they have hired you and you work for them. Line number 115, section 5, disclosures and acknowledgements. The buyer acknowledges and agrees to the following. 1, this agreement creates an agency relationship between the buyer and the broker pursuant to Kentucky state law, including KRS 324 and 201 KAR, chapter 11. B, broker and agent owe the buyer no duties other than expressly set forth in this agreement or by Kentucky law. C, receipt of and consent of the Kentucky Real Estate Commission's A Guide to Agency Relationships form from the broker that the broker and agent have respectively served in various agency capacities therein. This form should have been completed prior to filling out this form here that you're filling out now. So line number C is telling them that they are going to be signing disclosures, this guide to agency relationships. They have already signed this form and the agency consent buyer agreement prior to you going through this form with them. This is just an acknowledgement. D, receipt and consent of agency consent agreement buyer, part A from the broker. E, line number 122. The federal fair housing law prohibits discrimination in the sale, rental, appraisal, financing, or advertised housing on the basis of race, color, sex, creed, religion, national origin, handicap, or familial status, or sexual orientation, or gender identity in some counties, but if you're a realtor, it's all for all of us, and the receipt of a copy of the brochure, What Kentucky's fair housing mean from the broker? F. Broker shall not have any obligation to search out a property beyond any that come to the attention of the agent's ordinary course of the agent's business. Line 128 G, the broker may represent any prospective buyers or tenants, and those other buyers or tenants may have an interest in the same property as the buyer. Buyer agrees that the broker may, during the term of its expiration or termination, respect other prospective buyers or tenants, show them the same property or properties the broker identifies, locates, or shows the buyer, and act as a real estate broker or sales associate for such properties in negotiating the acquisition of property that the buyer also is interested in. You're gonna be working with other people and showing the same houses, possibly, potentially, to your other clients as well. H, broker is not responsible to monitor or supervise any portion of any construction or repairs of the property such that falls outside the scope of KRS 324 and 201 KR Chapter 11. I, buyer shall be responsible for complying with all the duties and deadlines contained in any contract or other document or agreements entered into by the buyer. J, there are no knowledge inputted between the broker agent and between other sales associates of the broker regarding any property in which the buyer develops an interest. K, which is line number 139. Broker and agent are not experts with respect to construction, building codes, common property regimens, engineering, structural matters, insurance, surveys, titles, inspections, appraisals, finance, mold, or other hazardous substances, termites, insects, law, tax, or other matters, and the buyer has been advised and agrees to seek independent professional expert advice on any of these matters. L. A broker strongly recommends that the client seek representation by an attorney for legal questions regarding acquisition of the property. M. In the event the broker provides names or sources of an independent or professional expert or legal advice or assistance, the client understands and acknowledges that the broker does not warrant, guarantee, or endorse the services, advice, and or products or recommend company or services. N. The broker makes no warranties expressed or implied with regard to any property that any statement by the broker about the property and will be and our opinion only. O, line 150. Broker does not warrant exact square footage or condition of a property or guarantee a potential seller has disclosed all defects in the property. 152. P. Megan's Law. The broker has no obligation to determine if any sex offender residence near a property in which the buyer is interested. The buyer should exercise whatever due diligence. Slide that down a little. Let me start back on 153. Buyer should exercise whatever due diligence buyer deems necessary with respect to information on convicted sex offenders. Kentucky Megan's Law establishes a registry of certain convicted sex offenders in which they can be found at Kentucky State Police, kspsor.state.ky.us/. Kentucky State Police establishes a registry or certain convicted crimes. The registry has been found at crimemapping.com. Broker has no obligation to determine if any crime has occurred near the property by which the buyer is interested. This is the end of page 3. At the bottom of the page, you must have your buyer's sign, initial, date, time. Initial, date, and time. At this point, we don't need a signature. Page number 4 is going to be our signature page. Let's scroll on down to page number 4. Wire fraud. Wire fraud is very common in our business and our industry. Line number 58 on page number 4 says wire fraud. Buyers should never transmit non-public personal information such as credit card, debit card, bank account, or routing numbers by email or any unsecured electronic communication. There are numerous email phishing scams that involve fraudulent requests to wire funds in conjunction with a real estate transaction. If a buyer receives any electronic communication directing to transfer funds or to provide non-public personal information, even if that electronic communication appears to be from a prospective broker, do not respond. Again, this is underlined, do not respond. Tell your buyers, do not respond. Such requests, even if they may otherwise appear to be from the broker, could be part of a scheme to defraud the buyer by misrepresenting transfer or funds by using the buyer's identity to confirm a crime. If the buyer should receive writing instructions via electronic means that appear to be from a legitimate source involved in the buyer's real estate transaction, buyers should verify using contact information other than provided in the communication that the instructions were sent by the actual representative of the requesting company. Conversely, if a buyer has provided wiring instructions to a third party, it is important to confirm with the representation of said company that the wire instructions were not to be submitted without the buyer's verified consent. When wiring funds, never rely exclusively on an email, fax, or text communication. Section number 6, line number 170, termination. A, either party can terminate this agreement within 10 days written notice, provided, however, in the event the broker terminates this agreement, the buyer shall still owe a broker fee to the broker with respect to any property within the scope if the buyer enters into a contract during the protection period. Line number 174, B, attorney fees and costs and expenses. In the event of any claim, controversy, or dispute arising out of concerning this agreement, and including without limitation a breach of contract by the buyer, a commission of claims brought by the broker, the revealing party shall be entitled to recovery from the non-prevailing party, such prevailing party's reasonable attorney costs, fees, and costs, expenses, including any professional or expert costs, fees incurred in litigation. In the event of the dispute, the parties agree to engage in non-binding mediation with the Mediation Center of the Central Kentucky or another mediator pursuant to the parties' agreement. The parties shall equally share the costs of the mediator. Further, if any party files litigation before mediation, the mediation provision shall be enforced in the court before litigation is permitted. Line number 182, this agreement is acceptable by the buyers, the broker, and the agent, and is effective at the last date and time signed by party hereunto. Saying, this is going to be, I needed to scroll this down. We've gotten to the signature part. The buyer is going to sign this form. Got 2 spots for the buyer on line 184. The broker is going to sign this form, and then the agent is going to sign this form on line 189. Your section that you are signing is 189. You take it to the office and the broker signs. On the bottom of page number 4, you have initials, dates, and times. Please do not forget to put the initials, dates, and times on the bottom of each page. If you have any questions regarding this form, please contact your broker with all questions. Any other questions could be directed to the Realtors Association of Southern Kentucky or the Kentucky Association of Realtors, as this form is a form for the Kentucky Association of Realtors. Again, consult your broker if you have any questions about this form. Thank you very much.